Hi everyone, my name is Bruce Moravchik and I am the coordinator of the NOAA Climate Stewards Education Project along with my colleagues Peg Steffen and Molly Harrison, and we're really proud and pleased to present Professor Robin Craig this evening to offer up our main presentation, the United States and Climate Change, Mitigation and Adaptation through Existing Federal Environmental and Natural Resource Laws. We'll start with just a few announcements, and then I'll bring Professor Craig onto the line. For those of you who have been with us before, tonight's webinar is being recorded, and links to a video archive are going to be distributed to you within a week of the broadcast. Now, if you don't get a link within 1 week, please send me an email with the subject, Request January 9th, 2017 webinar. I'll know what to do. Also, if you'd like to see links to our video archives and all of the slides that are presented this evening and previously broadcast webinars, you can go to the NOAA Climate Stewards Google website. Now, if you can't access the site, please send me an automatic access request through Google or send me an email with the subject, Request Access to CSEP Google site. To access the site, you'll need to have a Google account set up. For everyone who is attendant during the entire presentation this evening, you'll be receiving a certificate of attendance acknowledging your participation in 1 contact hour of professional development from us. You'll get this in your email. And all attendee microphones are going to be muted during the broadcast. If you'd like to ask Professor Craig or one of the NOAA Climate Steward staff a question, please type it into your GoToWebinar control panel, which should be appearing on the right-hand side of your screen. If you don't see it, it might be collapsed. Look for an orange arrow on the upper right-hand side of your screen and select it. Then the control panel should pop out. And also, during tonight's webinar, we're going to send you an email with a link to a post-webinar poll. Please open up your email right after the webinar and just answer. It'll take you less than 2 minutes. I promise you we read all of the respondents and look at all of the metrics. They're very important to our program. I have 2 announcements now, and I'll have some other announcements and some special education resources to let you know about after Professor Craig is done. The first is on, save the date, on Monday, January 30th, 8 p.m. Eastern Time, we have our next Climate Stewards Book Discussion Club. And we'll be talking about Will Jellyfish Rule the World? A book about climate change by Leo Hickman. Now, the book breaks down the causes and effects of climate change in a really fun, fresh, and easy to follow format. It's packed with everyday things that we can all do right now to make a difference. Will Jellyfish Rule the World is a pretty comprehensive, easy to use eco-handbook for classrooms. And we're also, for those of you who may not necessarily be able to get the book in time, we're also going to be talking about the TED Talk, The Pursuit of Ignorance by neuroscientist Stuart Firestein, which deals with the nature of scientific investigation, such as what does real scientific work look like. In the video, Dr. Firestein, he actually jokes that it looks a lot less like the scientific method and a lot more like, quote, farting around in the dark, unquote. So he really gets to the heart of science as it's really practiced, and he suggests that we shouldn't value what we don't know or high quality ignorance, or we should value what we don't know or high quality ignorance just as much as what we do know. And I also, so stay tuned for that. If you want more information, you can let us know here or send Peg Steffen an email. And we'll be also on Monday, February 6th at 7:30 p.m. Eastern Time. Almost a month from today, we have our next Climate Stewards webinar, which is sharing the climate change story with young learners through Elementary Globe. And in this webinar, we're going to be sharing a new Elementary Globe program storybook and a set of classroom activities that showcase the science of climate change. The book's called What in the World is Happening to Our Climate, and it builds on K-4 student understanding of climate science through storytelling, where the kids in the story employ science and engineering practices to the next, as they explore the world. Now, the 3 accompanying classroom activities are all aligned to the next generation science standards as well as Common Core to help the students learn more about the difference between weather and climate, the impacts of sea level rises on coast, and solutions to slow climate change. And so those are our primary announcements. And with that, I'd like to turn the screen over to Professor Craig, and at the same time, just read a little bit of her bio. So Professor Robin Kundis Craig is the James I. Farr Presidential Chair in Law at the University of Utah's S.J. Quinney College of Law in Salt Lake City. Now, Professor Kundis is also the acting director of the Wallace Stegner Center for Land Resources and the Environment for 2016 through 2017 and is an affiliated faculty with the university's Global Change and Sustainability Center. Now, she specializes in all things water, including the relationship between climate change and water, the water energy food nexus, the Clean Water Act, the intersection of water issues and land issues, marine biodiversity, marine protected areas, and marine spatial planning, water law, and the relationship between environmental law and public health. She's the author or co-author of 6 books, The Clean Water Act and the Constitution, Environmental Law in Context, Toxic and Environmental Torts, Comparative Ocean Governance, Place-Based Protections in an Era of Climate, Modern Water Law Concepts and Insights, and the End of Sustainability. Now, if that wasn't enough, she's also edited several other volumes and written over 100 law review articles and book chapters. And in her spare time, she's been appointed to 3 successive National Research Council committees on the Clean Water Act and the Mississippi River, 2 successive National Research Council committees on the Edwards Aquifer Habitat Conservation Plan, and consulted on water quality issues with the Government of Victoria, Australia, and the Council on Environmental Cooperation in Montreal, Canada. And she was one of 12 marine educators chosen to participate in the 2010 program in the Papahānaumokuākea National Marine National Monument on Midway Atoll. She's active in the ABA section on Environment, Energy, and Resources, where she chaired the 33rd Annual Water Law Conference in 2015. She served as the chair of Water Resources and Marine Resources Committees there, and has served on SEER's Executive Council. I could go on and on, but I will close with saying at the University of Utah, she teaches environmental law, water law, ocean and coastal law, toxic torts, and property. And with that now, it's all yours, Professor Craig.
Thank you, Bruce. Good evening, everyone. Tonight I'm going to give you an overview of how the United States has been addressing climate change through existing federal environmental statutes with some brief forays into what might happen in the next couple of years. So to start out, we're going to be looking at both climate change mitigation and climate change adaptation, which do overlap. So as everyone is probably aware, when we're talking about climate change mitigation, we're generally talking about actions that either reduce the amount of greenhouse gases being emitted into the atmosphere, or ultimately that try to reduce the overall concentration of greenhouse gases in the atmosphere. Whereas climate change adaptation, on the other hand, we're usually talking about how people adapt or change their behaviors to deal with changes in the climate and its effects that are already occurring. There is an overlap of activities that both help climate change mitigation and help climate change adaptation, and together these 2 activities dictate most of how we will be dealing with future climate and the consequences thereof. So again, various activities can help with climate change adaptation, including changes in land use, what we do with our infrastructure, how we deal with public health and the kinds of things we worry about in public health. On mitigation, of course, energy conservation and efficiency is often at the top of everyone's list. Changing how we do transportation and fuel efficiency, capturing methane from landfills, and I'll be talking about that a little bit later. But then in the middle we have activities that can help with both adaptation and mitigation. For example, green infrastructure, the use of plants and other greener infrastructure can both help adapt to climate change by cooling buildings off, for example, but also help with mitigation by providing more ways to absorb greenhouse gases. So that's just an overview of what I'm talking about, these two different approaches to climate change. And Bruce, that leads us to quiz question number 1. So can you put that up?
Okay, everyone, this is an interactive poll. Please just select your answer right on the screen. And then we'll give you just a minute to think about this and make your selection. When we're done, I'll turn this back over to Robin. Okay, we've got about 85% of the folks voting. Just another moment. Okay, with that, here were your answers.
Very good. False is correct. We are, in fact, a party to the United Nations Framework Convention on Climate Change. We have, at least at the moment, also agreed to the Paris Accord. The United Nations Framework Convention on Climate Change is the umbrella agreement or umbrella treaty among the world's nations to try to keep climate change to a safe level and to promote adaptation. There's not a whole lot of specifics in it, but we are a party to it, and so we do have an international obligation to deal with climate change, and that, of course, takes place primarily at the federal government level. So, all right, so we're going to start with climate change mitigation and look at the primary federal environmental statute for dealing with climate change mitigation, which is the Clean Air Act. Just a brief overview of how the Clean Air Act works. For most types of regulation, the Clean Air Act starts with the EPA designating what are known as criteria pollutants. These are pollutants that come from many sources and can have an impact on human health or welfare. These include things right now like ozone and sulfur dioxide. Once the EPA designates those criteria pollutants, it then sets national ambient air quality standards. These are the maximum concentrations of these pollutants that everybody in the United States should be exposed to. They are health-based, and in fact they're fairly protective. They're designed to protect the most vulnerable people for usually a lifetime's worth of exposure, taking into account both cumulative risk and acute exposure risk. Once those health-based national ambient air quality standards are set, then several things go into motion. One is that each state comes up with a state implementation plan to make sure that all parts of the state will attain those air quality standards. But at the same time, there are also regulations in place to govern stationary sources. They tend to be big stationary sources like factories and power plants. And the EPA and to a certain extent California can impose some requirements on mobile sources, meaning cars and trucks, things with an internal combustion engine, and those regulations tend to concentrate on fuels and fuel additives, although they can also include some design features such as when the catalytic converter was put into automobiles. So like I said, that is very basic. It's a complicated statute, but that's a very basic outline of how it works. And the starting point for greenhouse gas regulation under the Clean Air Act was Massachusetts versus EPA, which was a decision that the U.S. Supreme Court issued in 2007. The starting point for the decision was a petition to the EPA to regulate greenhouse gas emissions from cars and trucks, mobile sources. The EPA denied the petition, saying it neither had the authority under the Clean Air Act and that the administration at that point was pursuing other methods of dealing with climate change. But the U.S. Supreme Court said no, the EPA does have the authority to regulate greenhouse gases under the Clean Air Act, that they do qualify as pollutants under that act. And they were not impressed with the EPA's explanation of why it was not going to grant the petition, saying in legalese that it was arbitrary and capricious or not otherwise in accordance with law, basically that it wasn't a reasonable enough explanation for refusing to regulate. Now, the Supreme Court did stop short of ordering the EPA to regulate greenhouse gas emissions, but it was pretty clear from the opinion that the EPA was going to have a difficult time avoiding those kinds of regulations, at least for mobile sources. So, Bruce, that takes us to quiz question number 2.
Again, please select your answers directly on the screen, and we'll tally them all up. In the meantime, Robin, while people do this, there were actually 2 questions that talked about treaties and accords.
Okay.
The first one was, is there a difference between a treaty and accord and an accord? And the second part of that was that one listener wrote that they didn't think that Paris was a treaty because a treaty would have required congressional approval.
And that is correct. The Paris Accord was an agreement among heads of state. So a treaty in the United States requires the ratification of the Senate, and the United Nations Framework Convention on Climate Change has that ratification. The Montreal Treaty is another one we've gone on to, but some of the other agreements that happen in the wake of the United Nations Framework Convention on Climate Change, such as the Kyoto Protocol, also were treaties. Treaties come under a lot of names. We did not ratify that one. But the Paris Accord is operating differently. It's operating as an agreement, like I said, among heads of state rather than as a full-on treaty, and so it did not need to go through Congress.
Okay, thanks. Well, with that, we've got pretty much everybody voted in, and these were the answers.
Okay, so it is not true that every attempt has ended in failure. Yes, the EPA has successfully regulated greenhouse gas emissions from cars and trucks, the mobile sources. It is attempting to regulate greenhouse gas emissions from stationary sources, but has had more limited success with the stationary sources, and in fact is in active litigation over that issue as we speak. So thank you, Bruce. So just to pull that back in, again, we have our mobile sources and our stationary sources. So for the mobile sources, the EPA has successfully put in regulations through several model years of cars and trucks. But with the stationary sources, like I said, there's been several attempts in various ways to regulate greenhouse gas emissions from factories and power plants, and so far the EPA has run into problems in the court. The U.S. Supreme Court has said that it can regulate greenhouse gas emissions from stationary sources if it's already regulating those sources for something else, but that as of yet greenhouse gas emissions on their own are not good enough to trigger regulation of stationary sources. And part of that is because the EPA has not yet gone through the normal process of designating greenhouse gases as criteria air pollutants or setting those national ambient air quality standards, which in fact would be fairly difficult to do with greenhouse gases, given the lack of scientific consensus on what a dangerous level of those concentrations would be. But on the mobile sources, just to get a little bit more specific, the emission standards for cars were actually established in two phases. Phase 1 covered model years 2012 to 2016, so basically all new cars for the last 4 or 5 years have been subject to these regulations. Phase 2 covers model years 2017 to 2025, and the projections are that by 2025 cars as a result will be getting the equivalent of 54.5 miles per gallon, and the rules collectively will cut 6 billion metric tons of greenhouse gases over the lifetimes of the vehicles sold, and families will save $1.7 trillion in fuel costs. Now, trucks and buses took a wee bit longer, but in August of 2011, the Phase 1 standards for trucks and buses went in for model years 2014 to 2018, and in August of 2016, the Phase 2 standards went in that will control through model year 2027, and again, these are expected to save some fairly large amounts of greenhouse gas emissions over the lifetimes of those vehicles. So we do have fairly substantial regulation of our mobile sources, at least cars and trucks and buses at this point. But the power plants, as probably everyone is well aware, the major rule to try to get to power plants has been the Clean Power Plan. There are good reasons why the EPA has been interested in power plants. They are a fairly large source of greenhouse gas emissions in the United States. And as a result, in August of 2015, President Obama and the EPA announced that the Clean Power Plan was going to be promulgated, was promulgated. States and numerous other plaintiffs immediately challenged the Clean Power Plan in the U.S. Court of Appeals for the D.C. Circuit, which is where you challenge all Clean Air Act regulations. Those challenges are still pending in the D.C. Circuit, but while they were in the D.C. Circuit on February 9th, 2016, just days before Justice Scalia died, the U.S. Supreme Court enjoined implementation of the Clean Power Plan even before the D.C. Circuit had rendered a decision. So while that regulation is out there, it has been enjoined by the U.S. Supreme Court. It is not going into effect yet. The legal challenges are still being decided. And as everyone listening is probably aware, the Clean Power Plan is targeted for removal by the incoming Trump administration. So this is one to watch to see what happens with the Clean Power Plan. Now there are a couple of procedural hiccups, perhaps. It's not as easy as EPA simply withdrawing the rule at this point because it is in court. The U.S. Department of Justice represents the EPA and all federal agencies when they're in court. So the Department of Justice will have to be consulted. The courts, the D.C. Circuit may have something to say about how the rule would be withdrawn if it is withdrawn. But nevertheless, this is one that everyone is expecting will be a target of the next administration, and we'll see procedurally what happens with that and whether the DC Circuit can issue its decision before the Trump administration can do something else with this rule. So Bruce, back to you. That takes us to our third question.
Great. Again, everybody take a look at your screen and let's see if you think the Clean Power Plan will survive 2017. And while folks are answering this question, you know, we had another question here, Robin, which is that the auto industry is hoping that Trump will roll back CAFE standards. What are your thoughts on the likelihood of that?
My read is it's not the highest priority for the incoming administration, and the lead time for anything involving cars and trucks and fleets is actually usually in the range of 2 to 5 years, because you can't just tell an auto manufacturer do something different and have it take effect immediately. So there might actually be some resistance from that from other members of that industry, but those also go through the Department of Transportation as well as the EPA. So I would think that would be a little bit more complicated. But you know, everybody right now is working on limited knowledge of what the new administration intends and how they might go about things, but my read is that's not likely to be one of the primary immediate targets for regulation.
Okay, thanks. And with that, we've got everybody's votes in. So we're going to close the polls now. And let's see what people thought.
Yeah, so hard to predict exactly what will happen. I agree that with most of you that probably Congress enacting the Clean Power Plan as a statute is not likely to be the result. Whether it fails in the courts or not is, of course, an open question, although the oral arguments seem to indicate that the D.C. Circuit, at least, would probably uphold at least large parts of it. Again, what happens within the EPA, if the EPA goes through the procedures it needs to go through to withdraw the rule, then the litigation in the courts is basically moot. And how long all this takes, of course, is the other part of this question. So whether it will take a full year or more to find out what happens to the Clean Power Plan is part of what we are all waiting to see. So I agree, it's really hard to predict how fast things will occur and how they will occur on this one. Thank you, Bruce. All right, so that finishes up the Clean Air Act. So moving on to our next statute that has to do with climate change mitigation. The Resource Conservation and Recovery Act, usually known as RCRA, is our statute for handling primarily land disposal of waste. And so to trigger RCRA, you have to have solid waste, discarded material. The courts have been fairly clear that RCRA does not regulate ongoing manufacturing processes. It doesn't kick in until there are wastes being disposed of. So if you don't have waste, then you're not dealing with RCRA at all. If you do have waste, then the second most important question is the waste solid waste, just non-hazardous solid waste, or hazardous waste? Waste can be hazardous for a lot of reasons, but most of them are regulated because they are toxic as hazardous waste. If it is a non-hazardous solid waste, then RCRA subtitle D kicks in, and that is primarily concerned with landfills. If it is a hazardous waste, then the much stronger and more stringent regulatory program in subtitle C kicks in, and that is designed to regulate hazardous waste from cradle to grave, from the moment they're generated to the moment they are treated and disposed of in accordance with the EPA's regulations. So that's the basic overview of RCRA. It does have connections to climate change mitigation, mostly in terms of non-hazardous solid waste. So for example, one of the mitigation strategies that is being proposed, particularly for power plants, but it can be used in other contexts, is carbon sequestration or carbon capture and storage. So as you are producing carbon dioxide, maybe methane, it would be collected and then pumped underground for storage. Well, this is land disposal of a waste, and so carbon sequestration and storage is in fact regulated under RCRA, even though it is a climate change mitigation strategy. The other aspect of RCRA that is important, I said RCRA subtitle D governs landfills, trying to keep them sanitary. As part of the federal regulation of landfills already, there's a requirement to monitor methane levels, but much more efficient from both a climate change perspective and an energy perspective to be capturing that methane as it comes off of landfills and using it as an energy source. So that is another aspect of RCRA. Not yet, this part is not yet regulatory, but the EPA has been helping companies figure out how to collect the methane rather than venting it to the atmosphere off of landfills. So that's all for RCRA. Bruce, do you have any questions on that?
Nope, we don't.
All right, I'll take that as a no. All right, so one of the statutes that deals both with climate change mitigation and climate change adaptation is the National Environmental Policy Act, or NEPA. NEPA at the federal level applies only to federal agencies and other federal actors, and it is triggered when a major federal action is being proposed that might significantly affect the quality of the human environment. Federal actions can be federal agencies acting in their own projects or permitting or financing other people to act. If that trigger is met, then the main requirement of NEPA is that the agency prepare an environmental impact statement, which is an assessment of the proposed project's environmental impacts, both immediately and cumulatively, but also an analysis of other things the agency could be doing that might have a lesser impact. Now, the federal NEPA does not have a substantive requirement that the agency do the least environmentally harmful alternative. Some states do. If you live in California, California's version of NEPA does in fact have a substantive requirement to it. but the analysis itself can be very revealing. Now, if you don't have a major federal action because it's a state action, NEPA doesn't apply, or if whatever the federal government's going to do is not going to in any way significantly affect the quality of the human environment, then NEPA does not apply. So why is NEPA relevant to climate change? Well, for several years now, the federal courts have said that climate change is a relevant environmental impact and that federal agencies should be considering climate change in their NEPA analyses. That led in August of 2016 to the Council on Environmental Quality, which sits in the Office of the President and does the federal government-wide regulations for NEPA. It issued its revised guidance on climate change in NEPA. And what that guidance said is that first, federal agencies should consider the potential effects of their proposed actions on climate change. And the recommendation was that federal agencies quantify the direct and indirect greenhouse gas emissions resulting from the project. These greenhouse gas emissions generally would serve for as the proxy for the project's effects on climate change, but the Council on Environmental Quality did not designate a default quantity of emissions that would qualify as significant or insignificant, basically indicating that it would depend on the larger context of the project, what would be significant or not significant. The second thing under the guidance that federal agencies are supposed to do is to consider the potential effects of climate change on their proposed actions. Now, this is particularly relevant if the project is going to be a long-term project. Say, for example, the federal agency is authorizing infrastructure that can last for 50 or 60 or 100 years. For example, a new nuclear reactor in the coastal zone. Then what climate change would mean for that project should be considered. And the CEQ said how will climate change alter both the project but also the project's environmental impacts over time should be considered. Now, in terms of what we might see going forward, this is guidance. It would be relatively easy for the Council on Environmental Quality to withdraw this guidance. But as I mentioned before, the federal courts themselves have also been saying that federal agencies need to consider climate change in their NEPA analyses. And thanks to separation of powers, I guess, no new president can directly control what the courts decide is a requirement. So that the guidance may definitely change, but again, there's that backstop of court opinions. So I consider it unlikely that climate change will be taken out of the NEPA arena. And this is just a study that was done on how many environmental impact statements have discussed greenhouse gases or climate change. And as you can see, most of those discussions come in the environmental consequences part of the environmental impact statement, about a quarter in the discussions of the affected environment, and then less in terms of the actual energy and greenhouse gas emissions impacts or the cumulative impacts. So climate change for the moment, and I think for the foreseeable future, is part of NEPA, both in terms of mitigation in the sense of what kind of greenhouse gases are being created, and in the sense of adaptation, how will projects that are being developed be impacted by climate change itself. So Bruce, that raises our last question.
One that is particularly interesting for those of us in federal agencies. Oh, and by the way, Robin, if it's possible, we actually did have a question um, earlier on about if you could review again the Supreme Court's what they had to do with the Clean Power Plan, and just going over some of that terminology. Maybe we could cover that a little bit later on after your main presentation.
Okay, remind me, please.
I will. And just as a note, we've got almost 80% of everybody voting. So please just go and click on your selection on your screen pretty quickly. And we're going to close it up now. And what we've got.
Okay, well, the answer I think is a resounding yes. The fact that the environmental impact statement process is public, it has to be disclosed to the public. The public can comment on the process, and it's also subject to litigation if the agency does not go through the process correctly. Has on several occasions that public pressure has in fact resulted in federal projects being changed as a result of the analysis process, even though NEPA itself would not require a substantive change in the project. So yes, it can make a big difference, but the key is that it is a very public process, and the public occasionally pays very close attention to what the agency is analyzing. So thank you. All right, going on to our next statute, and the issue of climate change adaptation. We'll go to the Endangered Species Act. The Endangered Species Act is a little bit different because it's only triggered if the relevant federal agency actually lists a species for protection. The U.S. Fish and Wildlife Service has jurisdiction over terrestrial and freshwater species. The National Marine Fisheries Service within NOAA has jurisdiction over marine species and anadromous species, fish that start their life in freshwater, migrate out to the ocean, and then come back to freshwater to spawn, like salmon is the key example. Once a species is listed, it gets two sets of protections under Section 7, which applies only to federal agencies. All federal agencies must ensure that any action that they take, fund, permit, license, etc., will not jeopardize the continued existence of the species or damage or destroy its critical habitat. And then the second set of protections is in Section 9. These apply to everyone. The Section 9 prohibitions relate to how you can trade in endangered and threatened species, but they also prohibit the take, that is the capturing or killing, chasing, wounding. There's a whole lot of verbs in that part of Section 9. How you can interact with species. So those are the two sets of protections. The question that arose with climate change is, can climate change be a reason for listing a species for protection? And the answer has been a resounding yes. And also climate change is relevant to the jeopardy analysis. So some of the species that have been listed, at least in part because of climate impacts on their habitat, or usually habitat, but also directly on them. Probably most famous is the polar bear, which was listed as a threatened species by the U.S. Fish and Wildlife Service. But even before the polar bear, various species of coral, starting with 2 species in Florida, were listed because, in part, warming seas are a threat to the continued existence of tropical corals. And then, since then, a variety of other species have been listed, like I said, at least in part because of climate change impacts. This is the American pika, which was listed for protection because it lives on mountains and it's losing habitat. It needs to be at a certain temperature, so as it moves up mountains, it's losing the ability to migrate. So that is also listed, and the list of species that have been given the ESA's protections in part of because of climate change has been growing every year. And again, the courts have said that climate change is definitely something that has to be considered, particularly under Section 7 in terms of what qualifies as jeopardy to the continued existence of those species. So again, this is something that the courts have required as much as the agencies, and I don't see, unless Congress gets rid of the Endangered Species Act entirely, I don't think that climate change will be leaving the Endangered Species Act anytime in the near future. Any questions there?
Well, you know, Robin,
Okay.
we actually have an interesting question here, which is that
Sure.
considering that Trump doesn't believe that climate change is real, how can he affect federal actions?
He can through executive guidance and executive order say that certain kinds of actions like regulating greenhouse gas emissions are not priorities for the administration. If if he wanted to try to stop a species that was going to be listed because of climate change, he could, saying it doesn't exist. The problem with trying that under the Endangered Species Act is the Endangered Species Act also has a petition provision where citizens can petition to list species, and actually quite a few, and I think still the majority of species end up on the list because of that petition process. But he can shift federal priorities within agencies. Every president can, every president has. And so just by directing where the agency's attention should be spent, you can have dramatic effects on what kinds of regulations and also enforcement priorities the agency is generating.
I see. Would you mind if we popped over to just one question about NEPA?
Sure.
Yeah, one question, you know, a really interesting question that came over was whether or not Congress could redefine NEPA, removing climate change from the human environment, and whether or not the courts would have to fall in line with that.
Yes, to both questions. The interpretations of NEPA saying that that climate change is relevant to a NEPA analysis are a matter of statutory interpretation, which means that if Congress changes the statute, courts have to follow the clear intent of Congress in statutory language. It's only when you have a constitutional or other kind of issue at that level that courts can override the plain meaning of a statute.
Okay, great, thanks.
Okay, well then I will move on to the last statute for the evening, which is the Clean Water Act, and again has been most relevant in the climate change adaptation arena. Just a basic overview again of the Clean Water Act. So the ultimate goals for an individual water body are water quality standards. These are set by the states, or at least the states have the primary authority to set them, and they are set on a water body by water body basis, and they describe what that state wants that water body to eventually be able to support, whether it's cold water fishing or warm water fishing or primary contact recreation, which is swimming. Whatever the state thinks that a given water body within its borders should eventually be able to do, that's the water quality standards that the state sets. Then the Act directly regulates what are known as point source dischargers, usually factories, businesses that are discharging usually through something like a pipe is the quintessential point source, but an identifiable discharge into a waterway. And a POTW is a publicly owned treatment works. One of the very early focuses of the Clean Water Act were sewage treatment plants. And first of all, getting people on sewer systems and then making sure that sewage treatment plants were not discharging raw sewage into our nation's waterways, which was very typical before the Act went into effect. The Act also regulates what are known as indirect dischargers. So these are people who discharge waste into the sewage system, which goes to a sewage treatment plant. And the primary focus of those indirect discharge requirements are to ensure that whatever those dischargers are putting in the sewage system doesn't upset the sewage treatment plant. So a lot of that regulation is focused primarily at toxics, which sewage treatment plants can't usually deal with. Then not regulated under the Act are what are known as non-point sources. These are diffuse sources of water pollution, usually because of runoff or snowmelt. So parking lots, vacant lots, forestry lands are all good example of things that are classically non-point sources. Congress is well aware that they existed, but regulation of non-point sources under the Act is largely left to the states. So one of the most predicted impacts of climate change is on water, and in a variety of ways. In some parts of the country, we will have hotter and wetter conditions generally, more frequent storms, more violent storms. In other parts of the country, like the West, the prediction is that there will be less precipitation overall, so drier, but also, importantly to many states that depend on snowpack as their primary water storage, that less of the precipitation will come down as snow and more as rain, which means more flooding in spring and less water available in the late summer and fall. So a lot of different water impacts predicted, all of which can affect water quality. If you're getting more violent storms, you're getting more runoff, that can affect water quality. If you are getting less precipitation overall, your total water supply is decreasing, your pollutants are concentrating. So all of this is relevant to how the Clean Water Act works. One of the conundrums that is already starting to arise in certain states is it comes through the Water Quality Standards Program. So as I said, states set the water quality standards for the water bodies within their borders, and those water quality standards have three components. The designated uses, what uses does the state want a particular water body to be used for? Again, cold water fishing, boating, swimming, whatever. The water quality criteria are then the specifications, preferably numeric, of what levels of pollution can be there and still support those designated uses. So what the pH level is, how low the sediments have to be, how low toxics have to be, etc. And then finally an anti-degradation policy, which basically limits how much worse waters can get since the Clean Water Act was enacted. And it's the anti-degradation policy that has some interesting implications for climate change, because under this policy, states basically designate 3 tiers of waters. So tier 3, these are the best. These are the outstanding natural resource waters. Think headwaters in the mountains. And those cannot be allowed to degrade at all. Tier 2 are the waters that are fishable and swimmable, and there are ways to allow those to degrade a little bit to allow for development. There's a long process the state has to go through to justify that, but it can occur. And then tier 1 is whatever uses were available at the time the Clean Water Act were enacted have to be preserved. And again, anything that you could do at the beginning of the Clean Water Act, you're not supposed to ever get rid of. Now, I've also put a tier 2.5 in here. A lot of states recognize a category that's not quite the tier 3 designation of outstanding natural resource waters, so that they can't be degraded, but they are really good waters that the state wants to protect. They just don't want to strap themselves into not being able to allow a little bit of degradation. But those tier 1 existing uses are what are on the front lines of climate change. And an example is wildlife or fish that depend on cold water. As waterways are starting to heat up, are being displaced from the waterways, the rivers, streams, lakes where they used to be able to live. And Montana is one of the states where this is occurring. In fact, Montana has a report entitled Hot Trout, detailing all of the streams in which, either because of increasing temperatures or decreasing water supply, temperatures are becoming too warm to support those existing uses. So this is kind of a problematic conundrum for the Clean Water Act at the moment. It probably does need a fix, and it's the kind of fix that might be sellable to the new administration, because it does give states greater, the way to fix it would give states greater flexibility with regard to those existing uses in their climate change adaptation responses. The most challenging climate change issue for the Clean Water Act at the moment, however, in part because the Center for Biological Diversity is dedicated to bringing these lawsuits, is ocean acidification. The Clean Water Act does apply to the oceans, and in particular requires pH standards. As carbon dioxide is absorbed into the oceans, the pH of the oceans is decreasing, and this is particularly acute in Puget Sound in Washington and some parts of Maine, and the state of Washington is actually getting to the point where it has enough scientific research to know that certain parts of its coastal waters are in fact violating their water quality standards for pH. So this is an issue to watch. It's another conundrum for the Clean Water Act because the source of the carbon dioxide is emissions into the air, which the Clean Water Act cannot regulate. And so we may be getting into some liability under the Clean Water Act that actually cannot be fully addressed through the Clean Water Act. So I will just throw that out as a conundrum and finish quickly with some take-home points. First of all, in the absence of direct congressional action on climate change, it is important to realize that most of the existing federal environmental laws have been harnessed to at least partially address climate change issues. However, few of these statutes are a perfect fit, a great fit for climate change issues. They weren't designed to deal with that issue, and their structures do not allow for a comprehensive climate change program across the federal government. that can emphasize the actions that can address adaptation and mitigation simultaneously, or allow for other kinds of coordination, such as under the Clean Water Act when emissions into air affect water. And these gaps are particularly noticeable with respect to energy conservation, land use planning, and water conservation, all of which have been traditionally state, legal, and regulatory issues. So we do have some gaps out there. I am not expecting them to be addressed in the next few years, but they are definitely out there, and we could use some improvements in the legal structure. So that's all I have, and thank you very much. I'm here for questions.
Thanks so much, Robin. And we have got some really great questions. What I'm going to do is I'm going to pose a number of them to you to answer, and then I'm going to shift and cover some education resources that we have for the great number of educators in our audience this evening, followed by some announcements. We'll end our recording, but then if you have some time, there are a lot more questions that if you have a little bit of time, we'd love if you can answer for some folks.
Sure.
Great. So, one question that came up about water and water rights was if you how you think the transboundary water research and regulations are going to be affected in the new administration. This one listener says that she's in Arizona and shares water with Mexico, and sort of along those lines, in general, just how water that travels through and is used in multiple states managed or maybe managed if laws are in disagreement between those states. So it's sort of both dealing with transboundary.
All right, well, in terms of water allocation issues, so water quantity issues, transboundary conflicts are usually addressed most often in the United States through interstate compacts, which are basically contract negotiations between or among the relevant states that Congress then approves. And once Congress approves them, that becomes both federal and state law. So most of the waterways where there have been transboundary disputes among states, most of them have been addressed through interstate compacts. Where the interstate compacts have not been able to be negotiated or have failed, the second most common route of resolving those issues is to go directly to the U.S. Supreme Court. The U.S. Supreme Court has what's known as original jurisdiction over disputes between states, so they can go there. And the Supreme Court has developed quite a body of law on what's known as equitable apportionment. And if one state is being damaged by the water activities of the other, it's usually the downstream state that's being damaged, then the Supreme Court will, on occasion, go ahead and divide the water between or among those states. Now, it's only actually done equitable apportionments about 3 times. So it's not something the court likes to do, but it can. And there are one of the famous equitable apportionment cases before the Supreme Court right now is between Florida and Georgia over the Apalachicola, Chattahoochee, Flint River system. Georgia wants the water for Atlanta. Florida wants the water for its oysters. And that is being litigated, being heard in the Supreme Court right now, and we'll see if the court thinks Florida is being damaged enough to actually go ahead and equitably apportion the rivers. The third way is for Congress to step in, and that's the rarest thing to have happen. If the states can agree, they can usually do an interstate compact. If they can't agree, Congress usually doesn't want to get involved either. But for the Colorado River, which is probably what the listener from Arizona was thinking of, Congress did get involved and help to divide up that waterway. Now, once you've got another nation involved, either Mexico or Canada, then you are into the treaty power, and we have treaties with both Mexico and Canada on how to divide that water up. If you're worried about the water quality, then the Clean Water Act's interstate provisions kick in. There are two sections of the Act primarily that require the EPA to pay attention to complaints from the downstream state, and there are ways to resolve water quality disputes across state boundaries under that Act.
Thanks. We have some other questions here, and this may require you to offer a little bit of background, but
okay.
Well, just because it's somewhat specific, and all of our listeners may not get the know the background here, but how do you think that the Magnuson-Stevens Fishery Conservation and Management Act might play into climate change litigation over the next few years as fish stocks and fish habitats are adversely affected by climate change, and if fishing is not reduced accordingly?
Okay, well, some background then. Yes, the Magnuson-Stevens Fishery Conservation and Management Act is the major federal statute to regulate both commercial and recreational fisheries. It applies mostly to fishing that occurs more than 3 miles out to sea. The first 3 miles of coastal waters are usually the states to regulate. There are some exceptions to that, but it's usually up to the states to regulate fisheries in the first 3 miles. The Magnuson-Stevens Act works through regional fishery management councils, and those fishery management councils work to come up with fishery management plans for the fish stocks under their jurisdiction. So as part of those fishery management plans, the fishery management councils with NOAA are supposed to ensure that a fish stock is not overfished to begin with, that if a fish stock has been being overfished, that it is rebuilt, and that essential fish habitat is protected, among other things. Those are the most relevant here. And so if climate change is degrading a fish habitat or reducing the size of the stock, then that should be addressed through amendments to the relevant fishery management plan. The more interesting phenomenon with climate change and marine fisheries is that it's been well documented that several species are migrating. They're migrating toward the poles, which means that particularly along the Atlantic coast of the United States, the bulk of the fish stock may actually be changing management jurisdiction. And in fact, for some of the northernmost stocks, may be migrating out of the United States' fishing zone, the exclusive economic zone that we control, and into Canada's. So that's a more difficult issue, but it is one that NOAA scientists are well aware of. They've been doing a lot of the research to document these migrations. And again, that's another climate change impact that can be dealt with under the Act by simply migrating or sharing the jurisdiction over those migrating fish stocks.
Oh, that's really helpful. No, truly. And wondering also, we have another listener who's wondering if you could comment on the role of climate change in the Marine Mammal Protection Act.
The Marine Mammal Protection Act protects pretty much all marine mammals. However, marine mammals that are also listed for protection under the Endangered Species Act, or marine mammals that are considered depleted, both receive extra protections. As with the Endangered Species Act, the primary protection under the Marine Mammal Protection Act is against taking, killing, capturing, wounding, etc., marine mammals. And so again, if climate change, like there was the Pacific blob, this huge mass of hot water in the Pacific Ocean, for the last basically 2012 to 2015, it seems to be connected to a lot of the deaths of California sea lions. If climate change is having those kinds of impacts where a species becomes depleted or needs the extra protections of the Endangered Species Act, then those species would receive those extra, or should receive those extra protections.
Well, thank you. Now, I'm going to ask you two sort of final questions. We'll go through a bunch of this, and if anyone has asked a question, we'll stop the recording, but then we can ask Professor Craig the question afterwards. So one question is, could you actually just review how carbon dioxide or carbon capture and storage is considered a solid waste under the RCRA?
Okay, so the definition of solid waste under RCRA is actually very expansive, and it explicitly includes, this is in the statutory language itself, contained gaseous materials. So the fact that carbon dioxide is a gas does not bar it from being a solid waste under RCRA. It is a waste product of most combustion. We're not interested in the carbon dioxide. It's just what happens when you burn fossil fuels. And so it is material that is waste that's being disposed of, and when you go to contain it, it fits within the definition of solid waste. I think that gets at the question.
I think it does, yes. Thank you. And our final question, at least for our recording here, is in your opinion, what issues do you feel are most likely to be immediately impacted by a change in a top-level agency administrator, or sort of the low-hanging fruit?
For this next administration in particular?
I believe that was the bent of the question.
Yes. I think President-elect Trump and many of his appointees to date have made it clear that they're not convinced on climate change, and they've also made it clear that they want to get rid of the Clean Power Plan. So I actually do expect that to be one of the first targets. Like I said, it's going to be a little interesting procedurally to see how they go about it, given that it's already in litigation. But I think that will be very quickly dealt with. In the other one, in the environmental arena, that I think probably will not survive very long, is the Waters of the United States rule, which doesn't have much to do with climate change directly, but is very important to how the Clean Waters Act is implemented, also in litigation. Beyond that, I think one of the interesting questions to see is, how important the environment in general is compared to some other priorities that the incoming administration might have. For example, getting rid of Obamacare might be a higher priority. So to me, that's the biggest open question is clearly President-elect Trump is appointing heads of departments who tend to be pro-oil and gas, skeptical of climate change, which could have some implication for environmental regulation, but where that will fit in the new administration's overall priorities, I think, is one of the biggest open questions we have. And it's important to remember that presidents and the federal government cannot do everything at the same time. They really have to pick a few priorities to work through the system. So, like I said, that to me is going to be the interesting question over the next 6, 8, 9, 12 months is what actually rises to the top as the administration's main priorities and whether they are environmental or not.
Well, Robin, thank you so much for your time here this evening. I know how incredibly busy you are constantly, both with your speaking engagements and your teaching and your constant writing, and I am so pleased and grateful that you were able to join us here this evening and offer your expertise and knowledge to the NOAA Climate Stewards education community. And I'm going to make some final notes here on some resources and some announcements for folks. We'll stop the recording, and then maybe we can just get back to you in a few moments for a few more questions.
Certainly.
Thank you so much. So one thing we wanted to do is let folks know of some teaching resources, some really terrific information that may not necessarily be available after January 20th, particularly some excellent resources from the EPA. The first one is a student's guide to global climate change, and this is really a terrific entire series of online web resources for kids. If you have the opportunity to go in to grab these somehow, we really recommend that you do that. EPA Student Guide to Global Climate Change has videos, greenhouse gas emissions calculators, pages on climate science and climate change expedition for kids. These may be really useful in teaching climate change for you. And also the EPA's climate change homepage with links to regional impacts, links to data and reports, and mitigation and adaptation information. Also, EPA's homepage for the Clean Power Plan and state-specific sheets for the Clean Power Plan. Take a look at these resources. As I mentioned before, we are making a recording of this, so you can get back to this in a little bit. I also want to make this announcement for folks who didn't come in earlier. Go check your email. You've all gotten an email linked to our post-webinar poll. Really appreciate if you completed it right away and took it. I am looking at all of these results. And save the following 2 dates. Monday, January 30th at 8 p.m. Eastern Time, we have our next Climate Stewards Book Discussion Club, Will Jellyfish Rule the World? Book about climate change by Leo Hickman. And also, we're also going to be talking about the TED Talk, The Pursuit of Ignorance, talking about the nature of science investigation. And Monday, February 6th, we have our next Climate Stewards webinar, February 1, sharing the climate change story with young learners through the elementary globe, where we're actually going to be looking at an elementary book which was just developed and is available free online, What in the World is Happening to Our Climate, which is building elementary school students' understanding of climate science through storytelling and a number of NGSS-aligned educational resources. So please, I welcome you to join us for that. If you want to know more about that, get more information, please go to the NOAA Climate Stewards homepage, register for our listserv, we will get you more information and other professional development and educational resources regularly. And we just like to close this recording with your moment of Zen. This is actually at 1.8 million acres. This is the Grand Staircase Escalante National Monument in Utah. And it's in fact the largest national monument in the continental United States and the first one designated under the National Conservation Lands. So I'm going to leave this image with you as we say good evening and we close our recording. And I thank you all for joining us. Over 140 folks joined us here this evening. We'll stop the recording and we'll get back to some of your folks' questions in just a moment. This is Bruce Moravchik for the NOAA Climate Stewards Education Project saying have a peaceful and good evening. We'll see you soon. Bye-bye.